Okay, hi everyone. Good afternoon. This is great turnout for a snow-filled day. Really excited that all of you are here. Welcome to the Latham and Watkins Forum. I am so pleased to be here to facilitate a conversation with Noel Francisco, who was the 47th Solicitor General of the United States from 2017 to 2020 during the first Trump administration, and Elizabeth Prelogar, who was the 48th Solicitor General of the United States in the Biden administration from 2021 to 2024. Really grateful both of you made the trip and that no flights and trains were delayed to allow you to be here. So we're gonna have a conversation, and while we are having our conversation, think up of any questions you may wanna ask, because we'll save time just after 2 for you to come up if you have any questions to ask our former Solicitor Generals today. But let me just start with a basic question. It's basic, but it's very important, which is that Solicitor Generals are often, sometimes referred to as the 10th Justice. And it's really because of the special institutional relationship that Solicitor Generals have with the Supreme Court. But can you break that down for us a little bit more? Like, what do you view as the core non-negotiable functions and obligations of the Solicitor General to the Supreme Court? Because not everyone may be familiar with that term.
So I am happy to jump in, and I'll just say at the outset, I am so happy to be here and to have the chance to participate in this forum and have the discussion with both of you today. So thanks for that. So the 10th Justice, I'm going to borrow something that Justice Kagan once said when she was nominated for Solicitor General, and she was at her confirmation hearing, and she was asked by the Senate Judiciary Committee about this 10th Justice idea. And she said, I think the Supreme Court probably thinks of the SG as less the 10th Justice and more the 37th law clerk. And there was actually something to that. I think it was a pretty good insight, because it's true that there is a very special relationship. And it comes primarily from the fact that the Solicitor General's office is the quintessential repeat player in the Supreme Court. I think in my final full term as SG, we were participating in something like 90% of the cases that the court hears on the merits each term. And so you really develop this institutional relationship where the court is familiar, of course, with the SG and with everyone in her office, but it also needs to be able to trust and rely on the representations of the United States in litigation, because that is the way to preserve credibility and ensure that in all of those cases where the federal government is coming to court again and again, the court can trust that you are dotting I's and crossing T's and being really careful in how you're describing the facts and the record and the case law. So I guess in terms of this question of what was a non-negotiable aspect of the job, it was really trying to ensure that we preserved that kind of institutional credibility. It doesn't mean mistakes aren't made. I think every lawyer makes mistakes, and sometimes in fast-moving litigation, there were moments where we inadvertently submitted data to the court that turned out to be incomplete. But it does mean that you have to immediately own up to those mistakes and go to the court and explain what happened, and always, always try to ensure that you are scrupulously safeguarding the kind of reservoir of trust that's built up between the United States federal government and the Supreme Court in those merits cases.
Just to add to Elizabeth's story about Justice Kagan, I have never heard a Supreme Court justice refer to the Solicitor General as the 10th Justice. I think it's very true in the sense that Elizabeth was describing, that because you're a repeat player, there is this duty, this obligation of extra candor to the court, because you're going to be up there over and over again, and you need them to be able to trust what you're saying on behalf of the United States. But I think it's untrue in a much larger sense. Some people think of the Solicitor General as the quote-unquote 10th Justice because they view the Solicitor General as on par with the justices, where what the Solicitor General's office is trying to do is figure out what is the theoretically right answer to the law, much the way a judge is charged with figuring out not which interest they're siding with, but what is the right answer under the law. But at least in my experience, the Solicitor General is an advocate. You are advocating on behalf of the interests of the executive branch, And there were cases, I certainly had cases, I suspect Elizabeth might have had some cases where you thought, our position really isn't that strong, I don't think we're going to win this. But this is the interest of my client, the United States in this case, and we're going to do our best to advance those arguments on behalf of the United States. And so I think that sometimes people lose sight of that when they hear the moniker 10th Justice and think that the Solicitor General is not an advocate, when actually that very much is a core part of the job, advocating for the interests of your clients.
Yeah, it's, we should look up who came up with that term, or how did that get popularized, if not by the court itself. So,
Some Solicitor General, I think.
yeah, right, exactly. A very self-important Solicitor General. People obviously know about the Solicitor General vis-a-vis the Supreme Court, but what people who may not know is the degree of like the role that you're playing in lower court litigation, and it's actually quite significant. And you know, can you just tell the room a little bit about when and why the Solicitor General might get involved in cases at lower stages, and how are you? There's tons of litigation coming, you know, in the Justice Department. When are you getting asked to weigh in, and why?
So that's a great question, and I love talking about this because we get into what were actually my favorite parts of the job, which weren't actually arguing before the Supreme Court. That I did it because that was the job, but it wasn't my favorite part. Within the Department of Justice, the leadership consists of 4 people: the Attorney General, the Deputy Attorney General, the Associate Attorney General, and the Solicitor General. Within that leadership team, the Solicitor General is actually the only one that shows up in court and litigates cases. The other 3 are largely supervisors, managers, but the Solicitor General is an actual litigator. And that, in my experience, informed what role the SG played on big pieces of litigation that were important to the government. As the only actual litigator in that team, the team often looked to, and the White House often looked to, the Solicitor General to take the lead in strategizing over the litigation matters that were most important to the administration. And as we've seen in recent years, I think both of us saw this, some of the biggest initiatives that an administration is putting forward get litigated instantly. And so instantly you have a very high level of interest in how that litigation plays out. And that's the type of litigation that I found myself getting involved in. When the executive branch's major initiatives were being challenged from day one, these were a core part of the administration's policy initiative, and they wanted who they perceived to be their top litigator to be involved in helping oversee and handle that case from day one.
Can I just ask, and I'm going to come to you, but were you asked ever to get involved in cases, affirmative litigation at the Justice Department before it was actually filed, meaning like to help think through how cases might get developed and shaped, understanding that they were absolutely likely to go to the Supreme Court?
Yes, 100%.
Yeah.
And that's really what I was getting
Yeah.
at. It's actually my favorite part of the job today. Even today, my favorite part of the job is not the actual arguing of the cases, but you've got a client that's got an objective, and there's a thicket of legal woods in between where they're sitting and what their objective is.
Yeah.
And you need to help guide them through those woods to achieve their objective. And that is what the Solicitor General is often called upon when you're defending the administration's most important initiatives.
Yeah, and so Elizabeth, start here, but I'll come to you, Noel, too. Can you give an example just of one that stood out in your mind and kind of a little bit how it played out, where you got involved early on in a litigation in this way?
Sure. And you know, I'll echo what Noel said. This is actually a really great part of the job because as an appellate lawyer, and particularly as a Supreme Court lawyer, a lot of times you inherit the record that was developed below, kind of the facts are settled, and the legal strategy has been baked in from the start in a manner that might be quite frustrating if you didn't play a role in crafting that strategy from the outset, because sometimes you're looking at it and you think of some brilliant argument that you wish had been made or preserved, or you think, I bet those facts are out there, but we don't actually have them in this record because people weren't thinking about the case in exactly this way from the outset. And so one of the things that's really special, as Noel noted, is this opportunity, particularly in some of the most impactful pieces of litigation or federal policies that are being considered, to plug plug in kind of from day one as soon as a suit is initiated or even in advance of that. And the example that comes to my mind are some of the major initiatives that the White House was contemplating and that agencies were going to execute. Things like student loan forgiveness or the kind of vaccine policy for major employers, where DOJ was sometimes asked to weigh in even before a rule or policy was finalized to think through what litigation risk might exist, whether the policy was defensible, what kind of arguments we were likely to see in court, and to sometimes have a chance to then help shape the policy to ensure that we were being mindful of roadblocks or potential tripwires that could prevent that policy from being able to take effect. And so I really, really enjoyed the opportunity to partner with agencies and to kind of play a role in trying to advise them as a client in thinking through how to achieve their objectives, as Noel said. But there's one other category here that the SG gets involved in the lower courts, and it's not as public-facing as the Supreme Court litigation or even some of this very high-profile lower court litigation. It's all of the routine lower court litigation that's happening around the nation, where the SG plays a role in deciding whether to authorize appeals from adverse decisions. And this is a substantial amount of the workload of the SG's office because it requires any time the United States has lost in a lower court that you get personal SG authorization to further seek review of that, whether that's going to the Court of Appeals or seeking rehearing en banc, or of course filing a petition for cert in the Supreme Court. And I actually really loved this part of the job too, because it gives you this overview of the real breadth of litigation that the federal government is involved in around the country, and offers a chance to have a touch point to think more broadly and strategically about appellate strategy and cross currents between different types of cases, and thinking about whether particular appeals or pressing forward would advance the long-term interests of the United States.
And just on that, are there cases, I know the answer, but just to explain here, but are there cases where the United States is not a party, but it becomes clear during the pendency of the litigation that the United States may have a very strong interest? Are you also, are you looking at like litigation all over the country for this purpose to make sure that the interests of the United States are protected even when the U.S. is not a party?
Yes, very much so. And of course, kind of Exhibit A of that is in the Supreme Court, where when the court grants a case, we run a process for every merits case to decide whether to come in and participate as an amicus in order to bring to the forefront the particular interests of the United States that might be relevant and bear on the court's consideration. But in the lower courts as well, the United States will sometimes submit amicus filings in courts of appeals, or of course statements of interest in lower courts. And all of that is with an eye towards recognizing that even in disputes that are between two private parties on both sides of the V, a lot of times federal interests stand to be very directly affected.
Yeah. No, I don't know if there's a particular example of a case that stands out where you saw the importance of the SG kind of getting involved early.
Yeah, I don't know if it's where I saw the importance of it, but where there was no choice but to get involved early. When I started out in the President Trump's first administration, he very quickly put out a series of executive orders, including his travel ban. And the travel ban was instantly challenged, instantly enjoined, which sparked litigation all over the country on this. At the time, my recollection is there were two political appointees in the Department of Justice, me and the principal deputy for the Civil Division. So by definition, we were sort of thrust into the middle of this litigation. One thing I'll point out is, sometimes you hear about the so-called deep state, which I think is a pejorative term meant to criticize the idea that there are career employees that are trying to undermine what the executive branch is doing. I saw the opposite of that when I was in the Trump administration. I am quite confident that a lot of the lawyers in the Department of Justice didn't particularly like the executive order that the president had put out and that we were called upon to defend. But these were also career lawyers who understood that the role of a career lawyer is to defend an administration's positions. Yep. And you take these jobs from administration to administration, knowing that sometimes you're not going to like the policies. And the lawyers who we worked with in defending that executive order, they developed within the first 2 weeks the arguments that we ultimately won on in the Supreme Court. But it's a good example of where we worked from day one with all of the trial lawyers and appellate lawyers throughout the Department of Justice to put together the best arguments in defense of that order.
So, you know, a lot of people are noticing that the Supreme Court is increasingly taking cases during the pendency of lower court litigation. This is the emergency docket, in some places known as the shadow docket. And these are often cases presenting incredibly important or controversial issues. And so I am just curious, because this has not always been the case. Like, how has this development, do you think, and affected the work of the SG's office? And then separately, would love to get your thoughts about whether you think this trend has affected the Supreme Court's legitimacy or sense of legitimacy in the public.
So I think that the emergency docket has really transformed the work of the SG's office, and it's transformed the work of the court itself. You know, I got my start in the SG's office as a line attorney, a career assistant to the Solicitor General, and at that point in time, the emergency docket generally was invoked only in capital cases shortly before executions. It was not the docket that generally took on some of these kind of high-profile, very consequential executive branch policies or clashes between states and the executive branch. And the entire time that I worked as a career attorney, I didn't do a single application or opposition on the emergency docket because it just wasn't a thing. But if you flash forward, you know, just over the past 10 years or so, it has really exploded in prominence, and it's very much changed the nature of how the resources and attention in the SG's office are allocated and where they're focused. Because, you know, the kind of typical emergency docket case is one that is of profound significance. It usually involves some really consequential priority or policy of the administration. That means that the White House is focused on it. It means that it might be divisive or generate, you know, strongly held views about whether or not the policy should go into effect. It's often churning up a lot of litigation. And this question of what the status quo or ground rules are going to be while the litigation is percolating in lower courts is oftentimes kind of the whole ballgame. Because, you know, if you've got a case where the policy is going to be enjoined for the next 3 or 4 years, however long it takes for the ordinary litigation to run its course, then that is going to be very consequential in terms of the ability to actually implement some of those federal branch policies. So there's a ton of attention on that docket. And the court itself, I think, is devoting a lot of resources to the docket. You know, we've seen this kind of interesting development where more and more the court in certain cases is putting some more procedural process into emergency applications, so plucking them off the emergency docket and granting review on the merits so that there can be full briefing and argument, or at least hearing argument itself on the emergency application. You know, there's a lot of attention focused on whether the court is issuing enough reasoned explanation for outcomes on the emergency docket, and I think that carries with it some hard questions about whether you really want the court writing down reasons when it has to do so in this rushed posture on the basis of incomplete information, where that's then going to become kind of governing precedent that might create a lock-in effect. But of course, the counter-argument is, if you have the court just taking a vote up or down and then announcing what the rules are going to be on the ground, that can be very frustrating for litigants and for the American people.
And judges.
And for judges.
Some lower court judges who said, we don't actually fully understand
exactly
how to comply.
Yeah, and there's been, you know, some high-profile examples in recent months of lower court judges themselves expressing concern about their ability to follow the directions of the Supreme Court in a situation where they might not know whether the court found a likelihood of success based on a procedural issue like standing or based on the merits, and whether that's therefore going to govern the rest and course of the proceedings.
Yeah, I mean, the emergency docket was really driven by, and the growth of the shadow docket was really driven by the explosion of nationwide injunctions.
Yeah.
They started in the Obama administration, they accelerated during the Trump administration, they roughly kept pace during the Biden administration, and then they continued on through the beginning of the second Trump administration. The idea is that, you know, when a single district court enjoins a policy nationwide, you know, you basically have to go to your clients and you say, well, we lost in this district court, We think we're right. We think we're going to ultimately win. We'll tell you when your term is basically over. It's not a particularly palatable position to be in from a lawyer-client perspective. And so that put a lot of pressure on the Solicitor General's office to come up with creative ways in order to allow a policy to go forward while the litigation played out. And I think that has fundamentally changed the role of the Solicitor General's office, as Elizabeth said, and it's also really shaken up the docket of the Supreme Court. I wonder how it's going to continue given that the Supreme Court has really put the reins on nationwide injunctions. I think that if lower courts actually take heed of the CASA case, you're going to see a shrinking of the shadow docket, as you should. But it does result in some very fast-paced litigation, fast-paced decisions. One of my favorite cases was the case I argued against Elizabeth as her very last case as Solicitor General. And it was the case involving TikTok, where the Congress had passed a law essentially saying that TikTok had to shut down. We challenged the law in the DC Circuit. DC Circuit upheld it. We went to the Supreme Court on an emergency basis and asked for an emergency injunction against the law so that we could fully brief and fully argue the case on the merits. And then we dropped a little footnote that said, and by the way, feel free to treat this as a cert petition and just grant it and set it for argument, because that's what you do in these types of cases. Much to our surprise, they took us up on the footnote. They granted cert. I think we did complete merits briefing in 3 weeks, both sides.
Over the holidays.
Over the holidays, over Christmas and New Year's, and then argued the case a week after that, and had a decision 2 weeks after that. So that's kind of an example of how the shadow docket can lead to some highly expedited decision making. I think these are procedures that the Supreme Court is using more and more, I think mainly because of the criticism they've gotten over the shadow docket. And so I think a lot of that criticism was somewhat well-founded in that these were consequential decisions and there ought to be a little bit more due process that surrounds them. But that's the type of expedited decision-making we see now on the shadow docket. I do suspect, though, that there's going to be less and less of that as time goes on.
I'll share just on the TikTok case. I have 2 kids who are now 12 and 14, and so this is a case that actually broke through into the realm of middle school.
This is where my kids get all their news, so it's real.
And the night of that TikTok argument, as Noel mentioned, we were on opposite sides of the beyond that one. I went home, and my then 13-year-old said, "Mom, my friends were talking about your case at school today, and they were saying the Supreme Court's going to decide whether to ban TikTok." And so I said, "My mom's arguing that case." And they said, "What side is she on?" And he said, and I froze because I didn't want to tell them. So I just lied and said, "I don't know."
It's the only case I've ever had where my wife was against me and my daughters were for me.
So speaking of the TikTok case, both of you obviously served different presidents and argued cases of national, sometimes global importance, as it turns out, but cases that are of great interest to the White House. How did you approach those matters? What is the relationship between the Solicitor General and the President? How much independence did you have, in fact, or did you believe you should have? So getting into waters that I know are, under a lot of conversation right now.
So I always understood and respected that the SG serves at the pleasure of the President and ultimately reports up to the President through the Attorney General. And so either the Attorney General or the President, in theory, would be free to countermand any decision that the SG makes on behalf of the United States. But at the same time, there has been, and I think rightly so, a fair degree of independence that has built up around the SG's decision making. And I think in an ideal world, there will never be any need for the President or the Attorney General to do that kind of countermanding. And the way I approached it when I was in the job was to be very open in sharing information with both department leadership and with the White House, because I didn't think that it was in the interests of the government or in the interests of my office to try to kind of silo us off and create some kind of black box. I never wanted Attorney General Garland or President Biden to pick up the newspaper and read about some argument that we were making in the Supreme Court and to be completely shocked or surprised that we would be staking out that kind of position. But I felt like being open in sharing information and giving visibility into our decisional process was actually a really great way to try to safeguard the independence of the office. And a lot of it was about having a chance to explain our thinking in, why the decision was landing where it was based on this very internal and robust process of deliberation across the federal government. And so for me, it was kind of keeping open that line of communication that I thought best helped to safeguard those norms, as well as having leadership that I think was really bought into the idea that those norms are valuable and important.
Mm-hmm.
Yeah, and I had a very similar approach. I started out as a very young lawyer in the George W. Bush administration as one of the youngest lawyers at the time in the White House counsel's office. And there was always a saying back then that personnel is policy. Mm-hmm. If a president puts into place people who share his or her vision of where they want to go with the country and with the law, then the whole idea of independence generally is more theoretical, because you've put into place people who share your views and are 90% of the time going to independently come to the same position that the president might come to had he considered the issue on his own. And given that, my approach was very much the same as Elizabeth's. I wanted folks to understand what I was doing, what my thinking was. They had an opportunity to step in if they wanted to provide their views, but for the most part, I think they were quite comfortable with the views and never felt the need to step in. When it comes to dealing with the White House, I kind of dealt with the White House much as I dealt with other agencies. If I was defending an EPA regulation, I would consult with the EPA and with the EPA General Counsel's office to make sure I understood the EPA's concerns, what their goals and objectives were, so that could inform the litigation strategy. When I was defending an executive order, given that the White House counsel's office are the ones that essentially write the executive orders, I would consult with the White House counsel's office to make sure I understood what the objectives of the executive order were so I could properly defend that. But that was the general approach. You just keep people apprised of what you're doing and what your thinking is. They have a chance to provide their views if they want. Rarely is there any friction between them.
So it's interesting, Noel. It's an important point that this, to the extent personnel is policy, the heads of agencies are supposed to reflect kind of generally the policy prerogatives of the president. What people may not always recognize, though, is the SG also has to defend acts of Congress. And Congress, obviously, has a multitude of members of Congress and congressional, defending sometimes laws that may actually be quite contrary to a president's policy prerogatives. Can either of you remember a situation, a particular case where that tension very much existed, and how did you end up running a process or resolving it?
Yeah, so I have actually, I think, a great example that crystallizes the issue that you just put your finger on. Relatively early on in my tenure as SG, there was a case that the Supreme Court had granted a review on about the constitutionality of a federal statute that limited supplemental security income benefits for Puerto Ricans and who are American citizens. And it was challenged on equal protection grounds, and the First Circuit had said that the law was unconstitutional. The prior administration had sought Supreme Court review, and it had been granted. And President Biden, when he was campaigning, had actually put out a public statement saying, "When I'm president, this ends." So then he gets elected president, and I get chosen as SG, and there's this pending case, and I take a look at it, and the relevant question was not, is this a good statute and a good policy? Should Congress be denying SSI benefits to Puerto Ricans? Instead, the question was, is this act of Congress unconstitutional, and Congress has no discretion whatsoever in the matter? And when you looked at it, there was prior Supreme Court precedent to suggest that it was constitutional. So there was a stare decisis element to it, of not asking the court to overrule its prior precedent. There was kind of general equal protection principles and a framework that had built up that was of greater institutional interest to the United States. And my view was, we have quite reasonable arguments that this is constitutional, and it would be a pretty extraordinary thing to go into court and disavow the constitutionality of the statute. And so I briefed the White House on this issue and told them that my plan was to defend the statute consistent with this longstanding DOJ norm of defending acts of Congress if there's a reasonable argument. And made some of these points about how I would think that there would be kind of greater institutional interest in things like stare decisis as well. And the upshot was that the White House accepted the decision I'd made, and on the same day that we filed our brief in court, the White House put out a statement saying, the president thinks the statute is horrible policy. He calls on Congress to change it. But today, the Department of Justice is going to file a brief that defends its constitutionality because there's an important rule of law principle of DOJ defending acts of Congress. And we put in our brief, the president disagrees with the policy, but the question here is not whether it's good or bad, it's whether it's constitutional. And the court ultimately agreed with us, likewise emphasizing that the president disagreed as a policy matter, but that the constitutional question was the only thing teed up, and ultimately Congress had discretion and could change this policy if they wanted to do so.
I should say that's a real testament to the regard in which Elizabeth was held during the Biden administration, because that is a hard thing to do, to convince a president that something he has called for the invalidation of, to convince him that as a legal matter, even if you probably had plausible arguments that it was unlawful, to explain that the duty of the office is to defend that act of Congress and to carry the day. So I mean, it's a real testament to how they viewed you, Elizabeth.
It's a little hard to see that playing out in this Trump administration, but it must have been hard. Tell us about an example from your
Well,
tenure.
I'll give you a sort of a counter example, because Elizabeth is right. The basic rule is that you're to defend acts of Congress as long as a reasonable defense in favor of the act of Congress can be made, with one big exception, one big well-recognized exception. If the act of Congress actually implicates the president's own or the executive's own power, then you defend executive power over congressional power. So the one big case where I had this was a challenge to the constitutionality of the Consumer Financial Protection Bureau. That's the agency that oversees consumer protection issues. It was headed by a single member who was appointed by the president, confirmed by the Senate, but who could only be removed by the president for cause. So it was a limitation on the president's removal power. And our view was that that was in the heartland of the exception to the rule. That was where an act of Congress actually infringed on the president's own executive power, his own removal power. And so we were no longer bound under this practice of defending acts of Congress when a reasonable defense could be made. And so we ended up flipping the position of the United States and arguing that that removal restriction on the president was actually unconstitutional.
Yeah. A variation on a theme of this particular dynamic is both of you, I think, well, you were, I know, but you were SG at the turnover of the administration, right? So you're coming in to a set of cases where a different party was in power in the White House. And what people don't always appreciate is you don't just flip a switch and reverse positions typically, which can also put a president in the White House in an uncomfortable or awkward position. Just talk a little bit about how the SG is. How are you balancing at that type of moment where you're doing a turnover with a president of a different party in assessing the cases you're inheriting and juggling or balancing, maybe you're not balancing, the president's policy priorities with maintaining the institutional credibility for the SG's office? And why does it matter? Because it seems like it should be easy if there's a policy that is getting defended that is totally an anathema to the current president. What is this institutional credibility issue that you worry about?
Yeah, so a couple of things. When you start out in an administration, you often get requests to stop defending a particular policy that the administration no longer supports. And usually the response is, no, the defenses that we're making for that policy are the very same defenses we're going to make when we're arguing in favor of policies that you put forward. The right approach here is to change the policy. So if it's a regulation, if it's agency guidance, change the policy, and then we'll go into court and say, this case is now moot, the policy has been changed, there's no live controversy. That's usually how those issues got resolved. There are a handful of cases, though, where you're either defending statutes or you can't make changes like that, and so you are put in a position in deciding whether or not to flip the administration's position in active litigation. I generally approach that with what I would call a three-part test. Is the issue important? Are we right? And are we likely to win? And generally, all three of those factors would have to line up if I was even going to consider flipping the position. If it was important, but we weren't going to lose, but we weren't going to win, I didn't think it was worth the candle. If it wasn't important, it wasn't worth the candle. But if it was important, we were right, and we were going to win, then I thought that it was worth using the credibility of the office to do that. During my time, I think we did that 4 times. And in all 4 cases, we thankfully won, and so it validated the judgment that I was making. But it's something that I think almost every administration does a little bit. Everyone tries not to do it too much.
Mm-hmm. Yeah, I agree with that. I mean, I think that was one of the hardest set of issues to work through in the early days of the administration because, at the point when I became first acting SG, which was on day 1 of the Biden administration, there was an extraordinary amount of litigation that was teed up pending in the Supreme Court that involved signature policies of the Trump administration or, kind of issues that would likely reveal kind of a divide in legal framework that the relevant administration thought was probably the correct framework to apply. And with the policy issues, as Noel said, the obvious thing to do would be for the agencies to change policies. And then your role is quite ministerial. You go to the court and you explain that there's been a factual change on the ground and maybe the case is moot or it lacks continuing relevance and you suggest kind of next steps. But it doesn't involve a change in legal position in any relevant sense because you're not disavowing the legal arguments that were made. You're just explaining that the policy is going away. The much, much harder set of issues were those where there wasn't a relevant factual change in the world, but where there was a real concern about whether the prior legal position that had been articulated in the prior administration was correct and whether it served the interests of the United States. And for that set of issues, what I took comfort in was running a very significant amount of internal process to kind of vet internally how people were thinking about the relevant legal issue, how big a mistake it would be if the court accepted the arguments that had already been articulated in court, and how that would bear on the institutional interests and equities of the United States. And I'd say that I approached that set of decisions with a strong thumb on the scale of maintaining consistency because it does potentially use up credibility or suggest to the court that the United States is not always, being super thoughtful in articulating its positions if you just flip on a dime and suddenly everything is getting changed as at the start of an administration. So there was certainly a thumb on the scales in favor of maintaining. But ultimately, in the cases where I thought that we had taken the wrong legal position and it disserved the interests of the United States, then that would sometimes be enough to overcome the other considerations and would warrant a switch in position. Although, unlike Noel, my switches in position did not always yield ultimate success in the Supreme Court.
So I have to say, one of the things that was important to me when I was talking to the lawyers in our office was to emphasize that the job of a career assistant and our career deputies is to defend administrations across time. And so you need to put aside your own personal views and advocate whatever the interests of that particular government are, as long as you can make a reasonable argument in their defense. And I remember in one of your first cases, Eric Fagan, who we had made the Deputy Solicitor General in charge of the criminal division, had to go and argue the position opposite to the one that we took, even though he had to argue, I think, the position that we took the first time around. And I called him afterwards and I just said, Eric, congratulations, you did your job. This is what you're supposed to do. It's not your decision. Reasonable arguments are on both sides of this case, and you did your job and made the reasonable argument, even though it was I remember listening to that argument, it was a very difficult argument that he had to make in the Supreme Court.
Yeah. One thing I think that's not visible, everyone focuses on the cases where the change is made, And what you don't see is that kind of below the surface, there are all kinds of cases where people are lobbying for a change where the SG ultimately says no. So, I think both Noel and I, there were newspaper articles written about just how many positions we flipped, and I would read those and feel a little bit of a sense of frustration thinking, you don't know about the 20 other times I was approached and asked to change a position, and I decided to maintain what the prior administration had said. And I actually have a really vivid memory. When Noel became SG, I was a career attorney in OSG, and so I had the chance to work under Noel for a period of time. And in one of the cases that was pending when he became SG, he had been approached to switch our position, and we had already submitted the brief. I was prepping for oral argument. It was going to be my argument, and we had a meeting with Noel. I don't know if you remember this, Noel, but we had a meeting in your office. Ed Needler and Noel and I sat together, and we walked him through the case and why we thought it would be insane to change our position. And I remember Noel asking really smart questions and processing it, and walking out of there and thinking, I hope this case doesn't go away. And sure enough, about a couple of days later, Noel let us know that he was going to maintain and that, we were good to go with the argument. And so at the time, as a career lawyer, I'm like, how could he even think about it? But then when I became SG, I realized, well, of course, you always think about it when you're getting approached and people are saying that position you're taking is very out of sync with, kind of the policies and the general doctrinal jurisprudence of your particular president.
Yeah. And people may not know that the SG is frequently getting appropriately lobbied. Its memos, but from agencies across the federal government, and sometimes even by outside stakeholders who want to get a piece of the SG's time to be able to convince the office about not just what position to take, but potentially what arguments to make and not make at times. So it's a very involved process to figure out, in some cases, what the interest of the United States ends up being in the Supreme Court. So I think this is especially true for Noel, but during your time as Solicitor General, the composition of the court changed rather dramatically. The balance of thinking, insofar as the composition of the court changed a lot. How did that, for both of you, how does the composition of the court change the way you are evaluating the interests of the United States or the arguments that you are going to make, understanding, who each of the justices is, what might be persuasive or not?
I have to say, I've thought about this a lot, and honestly, it doesn't change.
Come on.
No, it doesn't. And I'll explain to you why. Because I'm a firm believer that a good argument is a good argument across the board, and a bad argument is a bad argument across the board. If I've got a really good textual argument, I'm going to lead with that argument no matter what the composition of the court is, because frankly, today at least, they're all largely textualists. If the text is quite clear, they're all quite loath to depart from the text. If I've got a crappy textualist argument, but I've got a really good common sense argument, I'm probably going to lead with that. So honestly, when I sit down and figure out how I'm going to approach a case, which arguments I'm going to lead with, which arguments I'm going to emphasize, I really don't focus on what the makeup of the court is or who the judges are. Now, when I'm trying to cobble together 5, or if you're in the Court of Appeals 3, I'll often be thinking, all right, what are the nuances that I need to use to move this judge or justice over into my camp? And it may be emphasizing certain parts of the text and bolstering that with certain policy arguments, but the fundamental principles are always the same. You want to have a good textual argument, and then you want to support that with common sense, why this textual argument makes a lot of sense. If you're arguing a constitutional case, you want to have good argument from the case law or a good argument for the original understanding, and you want to bolster that with common sense. And I honestly think that with good judges, and every justice on the Supreme Court is about as good a judge as you're ever going to find, with good judges, an argument that is persuasive is going to be the most persuasive, at least, to all of them. And maybe it won't be particularly persuasive to any of them or some, but going with a lesser argument usually isn't going to do, you're not going to do any better with a less good argument than you are going to do with your best argument.
Mm-hmm. Elizabeth, do you agree?
Well, I certainly agree that it's better to have good arguments than bad. But
okay, we've achieved that's a basic
consensus there.
Consensus there.
I guess I think that, nature of arguing has changed a little more than maybe it changed for Noel in a couple of different ways. So, the first is that I think particular types of legal arguments have become better or more good in the sense that as the composition of the court has changed, the court is going to kind of more naturally focus on particular doctrinal threads. And I'm thinking in particular, the role of history in constitutional cases. History's always been pretty important. It's always been one of the arguments. But I think that particularly on, looking at the composition of the current court, there are a number of justices for whom history is sometimes all but dispositive. And so if you look at how we briefed constitutional cases in the last administration, we almost always started with a very forceful historical presentation in recognition that if we were going to get to 5, history was going to be kind of the first and foremost consideration of a large number of the justices whose votes we wanted to be in play. I think it also has changed in the sense that, right now, with all of these new members of the court, they're all bringing their own jurisprudential philosophies to bear on the particular questions of the day. And it creates, I think, a little more room for creative lawyering, thinking about how exactly to thread a needle to garner a majority of votes. When I first started practicing in the court, it was thought of as a 5-4 court with Justice Kennedy being the swing vote in most of the critical big cases. And it felt to me like people were very much orienting their advocacy around Justice Kennedy, and they would throw in gratuitous quotes to Kennedy concurrences in marginally relevant cases, just to show that they knew what he was thinking about and concerned about. And there was just so much attention focused on that one member of the court. And I just don't think it's like that in today's court. A lot of times when I was SG, I would be thinking hard about how I might form a coalition. And maybe I didn't think I was likely to get Justice Gorsuch on the merits, but he might be with me on remedy. Or maybe I could get Justice Barrett's vote on some threshold issue related to standing. Or, just kind of thinking in terms of breaking down the case even at the granular level of specific arguments that might resonate with specific judges and therefore how you might actually find a path to victory.
Mm-hmm. It's interesting. I'm going to shift gears a little bit. And remember, think of your questions because they're about to turn to you. But so, there's a lot of law students, lawyers, people in the profession are quite concerned about the increased attacks on judges, concerns about the strain on the rule of law right now, questions among some in the public about the court's legitimacy. I'm just curious, how do you assess these developments right now? They feel particularly, on people's minds right now. And what responsibility do you think that institutional actors like the Solicitor General have, if any, on reinforcing public confidence in the rule of law and the judiciary?
I mean, for me, what I find to be the most troubling development in the modern political climate is the inability of people of different views to actually have a civil discussion over their views. And I actually think that's what infects all of these other areas and causes problems in all of these other areas. And I've always thought that one of the most important roles of lawyers, and particularly of the Solicitor General, was to be a model on how you can discuss very difficult, very controversial, very sensitive issues with people with whom you disagree, either because you actually disagree or you simply represent interests who are on other sides of the V from one another, how to have that conversation in a civil way. After all, the whole idea of civil litigation and civil courts is to provide a system where we can resolve our disputes short of violence in a civil way. And as the representatives within that process, I think it's our job and our obligation to model that kind of civil discussion and civil debate. I thought that was extremely important when I was Solicitor General to try to emphasize that when I argued some very controversial cases on hot issues. I always spent a lot of time thinking about how I wanted to describe the issues in a way that would take down the temperature. The issues were inherently controversial. They were inherently going to get people pretty riled up, both intellectually and emotionally. And I didn't want to add to that through my rhetoric. Instead, I just wanted to use a very level, civil legal discussion about what the issues were and why, in my view, they ought to be resolved in my favor.
Mm-hmm. Yeah, you know, it's interesting. There's this tradition in the court of calling opposing counsel my friend. And I always kind of chuckle at this because usually, you know, when I would refer to my friend, it's because I was gearing up to set out to utterly destroy his point, right? But I think it actually reflects.
Having been on the receiving side of that friend.
It redefined friend is what you're saying.
But I think it gets to the heart of what Noel was saying, which is that, you know, we're litigators, and so we're kind of by definition oppositional. We're on different sides of a V, and yet that doesn't mean that you have to sacrifice collegiality or assume bad motives or use ad hominem attacks or take the temperature up with rhetoric. You know, I think that some of the most powerful advocacy can come from showing respect to the other side, acknowledging the force of some of their better points, and using the force of persuasion and legal analysis to demonstrate why nevertheless you should prevail, and that it is really important to kind of maintain on behalf of the SG's office that very high level of integrity and collegiality in conducting litigation. You know, to the broader point of, you know, where we are in this moment with respect to the judicial system and attacks on the rule of law, you know, I'll say it's certainly the case right now that the judicial system is under a microscope, and the Supreme Court itself in particular is under a microscope. And I think a lot of that has to do with the fact that right now, when you think about the various checks and balances that our framers anticipated, Congress is not doing a lot by way of a check. And so a lot of the kind of separation of powers work right now is being handled vis-a-vis the judicial branch examining what the executive branch is doing. And that creates kind of natural potential for conflict. But I guess for those who are feeling disheartened or frustrated or unhappy, you know, my view is, wow, the courts are stepping in and doing their job. You know, I am amazed every time I read about how something's happening. People are getting loaded on planes to be deported, or there's something happening in the world, and a lawsuit is filed almost, it feels like, instantaneously. And courts are sitting on, you know, early Saturday mornings to hear those disputes and issue their rulings. And so I guess for the law students in the room, I would say, you know, you're entering a profession where through your advocacy and through using this branch of government, you can really make a difference in kind of shaping those checks and balances and the separation of powers that's so critical.
Super important points that both of you have made. And if you have questions, please come up to the mic. You can get lined up. And while people line up, and don't be shy, please. I'm going to ask one question, which is, you know, and actually to your point, there's actually been a spike in law school applications the last 2 years, which I think even amidst this climate, you know, speaks to what you're talking about. But for the students who are like, how on earth did Noel Francisco and Elizabeth Prelogger get the jobs that they got as appellate lawyers or as Solicitor Generals? Can you speak just quickly about some of the career advice, and then I will come to the mics.
You know, when I was in law school, I was at University of Chicago. I was very convinced that I wanted to be a products liability trial lawyer. And so I applied to, I had Richard Epstein for torts, loved it. And so when I was applying for clerkships, I only applied to district court judges in Chicago, thinking I wanted to clerk for a district court judge, see how trial lawyers plied the trade, and then go on to become a products liability trial lawyer. Through a series of happenstance, a friend of a friend happened to be clerking for a judge on the Fourth Circuit Court of Appeals and had befriended another judge on the Fourth Circuit Court of Appeals, Mike Ludig, who was having a hard time finding law clerks that year. I hadn't applied to Mike Ludig, but his chambers reached out to me and asked me to apply, so I applied. I flew down, and I got the job. Ludig, a lot of people might not know, but he was Justice Scalia's very first law clerk when Justice Scalia was a judge on the D.C. Circuit. And so as a result, Scalia always hired one Ludig clerk. When I got to the Ludig chambers, he had 3 law clerks. The other 2 had already gotten clerkships with Thomas and O'Connor. so Scalia had to take me. So that was pretty much it. I got a clerkship with Scalia. I ended up landing at this small litigation boutique in Washington, D.C. called Cooper, Carvin, and Rosenthal. I was the third associate they ever hired. The second associate was Ted Cruz. Our summer associate at the time was Tom Cotton. Jim Ho was our other summer associate.
Wow.
It was a crazy place. Florida recount hits in 2000. Ted is on the campaign putting together the legal team. We all go down to Florida to help litigate the recount. And then when Bush wins, the entire White House counsel's office, save Judge Gonzalez, is staffed with people who were down in Tallahassee litigating the Florida recount. So that's essentially how I got into this whole.
Okay, so
I
good
hope
luck
you all are
trying to
taking
remake.
notes,
Yeah. Good luck trying to remake and follow that career. But it is fascinating. It's kind of like life happens. Like you just don't know.
Well, that's exactly
just
my
don't
point,
know.
though. It's that be open to
Yeah.
opportunities. You might have a very set view on what you want your career to be like, but there are so many ways to have a satisfying legal career. And just be open to the different ways that might not fit what you think a good legal career would be right now.
Oh, I would echo that times 1,000. I mean, being open and receptive to opportunities as they arise, even things that push you outside your comfort zone, maybe especially things that push you outside your comfort zone. You know, when I look back on the course of my career, those have been the greatest opportunities for growth and have sometimes helped yield insight for me about what I think I'm good at and, you know, what in the law is not as great a match for my particular skill set. It will lead sometimes to unanticipated relationships and mentoring opportunities developing. You know, for those who are interested in appellate law in particular, I guess to try to make the advice a little more concrete, I would say learn always or be open always to learning more about how to write. I feel like I'm still, you know, studying briefs that I think are beautifully crafted and trying to reverse engineer what makes them so effective. When I was a younger lawyer and I got edits back from more senior attorneys, even if they didn't send it in red line, I would run the red line and then pore over the changes and think about why the attorney had made those edits and what the wording choices revealed. Look for opportunities to get stand-up experience in court. It can be hard, especially as a more junior lawyer, but oftentimes those first oral argument opportunities might happen in the pro bono space, and that's a really fantastic way to have a chance to argue while also doing some good in the world. A lot of times they might happen in public interest jobs or in working for state or federal government employers. You know, I definitely would not have become SG if I hadn't come to the department at an earlier stage in my career and had the chance to work in the SG's office as a career assistant. And it was an amazing opportunity as a relatively, you know, junior or mid-level attorney to actually have the lead on briefing and arguing cases in the Supreme Court. So I would say kind of reach out and grab those kinds of opportunities whenever they arise, and don't count yourself out. Don't think that it's not going to be something that's open to you just because you don't check the box of having been there for the Florida recount. You know, you will be surprised at how often there's serendipity and there's this kind of chance to make these kind of twists and turns in your career turn into exactly the path that in retrospect you realized you wanted.
Okay. Who's at the first? And okay, then I'll go here and then to this mic if there's somebody at this mic. Go ahead.
Hi, Generals. Thank you so much for being here. We often hear things to the effect of Supreme Court oral argument maybe isn't as important as it used to be. It's not often, you know, what makes the difference. So I'm wondering if you have examples of cases that you've argued where oral argument actually ended up being decisive to the outcome.
I think the conventional wisdom that, you know, the brief is where cases are generally won and lost, that there's a lot of wisdom to that, and that it's true that that is, of course, your biggest opportunity to kind of try and make a difference in your case and have, with the fullness of time, your most complete exposition of your legal arguments. But I'm also a big believer in the idea that oral argument matters quite a lot, often in terms of the kind of particular way that an opinion gets drafted, how broad or narrow the court might go, whether there are little carve-outs that could make a difference. In terms of the question of, an actual example where I think oral argument mattered, the case that comes most to mind for me is a case that I argued, kind of near the end of my time as SG. It was in the aftermath of Dobbs, and it was a case about the understanding of the federal statute that governs care in emergency rooms and whether women who are facing, grave dangers to their life or health have a federal right under that statute to be offered termination of the pregnancy if that's the only thing that might save their life or save their health in a way that is often in a crisis emergency situation. And the state of Idaho had a very restrictive abortion law that would bar termination even in circumstances where it would run counter to kind of the obligations we understood the federal statute to provide. So the federal government sued Idaho on this preemption theory, and Idaho obtained a stay from the Supreme Court, so that, on the emergency docket, suggesting that Idaho had a likelihood of success on the merits. But then the court granted review in the case, and it went to full briefing and argument later that term. So that was a case where, the preliminary take from the court at the outset was that Idaho was likely to win. But we had this amazing team on it at DOJ who worked extremely hard in gathering all of the relevant information about the precise contours of the conflict we perceived between Idaho law and these very rare but really significant emergency situations, and what Idaho law would prohibit. And I walked into the oral argument in that case and had a very intense argument where there was a lot of questioning from the bench, Justice Barrett in particular, that really drilled down on some of the medical evidence about, what are the circumstances where this conflict could come up? When are you saying women can't get emergency room care? And we really went deep in the weeds on some of that information. And at the end of the day, the court dismissed the case as improvidently granted. So it's not like they flipped on the bottom line, but they also dissolved the stay. So it changed the status quo of whether you could get care on the ground in Idaho. And was kind of a direct reversal of what the court had done at the emergency stay stage. And I think that was one where the oral argument really did make a difference.
Yeah, no, I think that rarely have I seen a case where it changes a win to a loss or a loss to a win. But I have seen many cases where it narrows the scope of the win or narrows the scope of the loss. The very first case I ever argued in the Supreme Court was against our predecessor, Don Verrilli, another fine lawyer and human being. And it was called NLRB against Noel Canning, and it was a challenge to President Obama's recess appointments to the National Labor Relations Board. I represented the Noel Canning Company challenging the recess appointments. There was a broad way that we could win, and there was a relatively narrower way that we could win. From my client's perspective, it got in the same relief, so I didn't care that much. But there was but it mattered a lot to the United States government whether they lost on the broader rationale or the narrow rationale. And Don really just did a masterful job. He recognized right off the bat that the United States was going to lose this case. We ended up winning it, bottom line, 9-0. But he did a masterful job of guiding the court to ruling in my client's favor on the narrower ground. And I think that his argument really did have a huge impact on that.
Great question. Go ahead.
Hi, thanks for both of you for coming here. So with regards to the strategy and just like working with a team in the SG's office, I remember Dean Morrison spoke earlier this year regarding, I think it was the Sebelius case, the Obamacare case, and with regards to the strategization of how they were actually going to make the argument, and then with regards to just trying to give a legal rationale as to defending the mandate. And then Obama went in front of the podium and then said that this would not be a tax, and that was exactly what they were going to try and argue before the court. So I guess my question is, A, how do you go about strategizing with the other members of the SG's office when making your legal argument? And then also, B, how does the president or anyone for that matter, if it's a case of great public concern or something that's highly controversial, how does that affect that legal argument?
You mean the words of the president, or a cabinet member or something else on an issue?
Or whether it be the agency head, whomever they may be.
I've spent most of my career litigating against the federal government, not defending the government. That's
Me too.
essentially the core of, that's the core of my private practice has always been to litigate against the federal government. And early in my career, it was largely litigating against the Food and Drug Administration on behalf of tobacco companies, because one of my law firm's biggest client was a tobacco company. And one of the things that we found so frustrating is that we realized that once you're approaching oral argument, usually about 3 weeks before argument, they were going to issue some new guidance or some new regulation that was going to try to upend the entire apple cart. So I think that within the government, you do have, particularly in this type of administrative litigation, an ability to shape the record in the government's favor if you use that in a sort of thoughtful way. Now, I think often the government isn't thinking about this and isn't using their powers as much as they potentially could. But sometimes, particularly when the SG's office is involved early on in helping to shape the case, you do see the government using the tools that it has in order to shape the record in a legitimate, but in a way that is most favorable to the government's position.
Yeah, one of my favorite things about being an appellate lawyer generally, both during my time in government service and in the private sector, is just having the opportunity to really be a generalist across the range of cases where you don't necessarily have subject matter expertise in just one area of the law, but what you are really expert at is thinking through how to kind of creatively litigate appellate arguments across the range of subject matters where that arises. And so there's a really great element to it of getting to work with colleagues and having those strategy sessions and kind of brainstorming different ways of making arguments and thinking about what's likely to resonate or what's likely to land. And each case is kind of its own animal in this regard, where sometimes the arguments are pretty baked in and it's very obvious how the case ought to be argued. But it's actually interesting how frequently it's more of a green field in the sense of really you can kind of come at it from many different ways, and you have to make these choices about what your lead argument is going to be, what points to emphasize, what concessions or limiting principles potentially to recognize. So it's a really, really fantastic element of, I think, being able to serve as an appellate lawyer.
But I will say, from having overseen the civil division as associate, that there were plenty of times where litigation was pending and a government principal went on TV on the Sunday show and said, blah, 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 and may have thought it was like politically helpful or just, had not been coached by their GC very effectively or White House counsel. And you're like, oh my God, we just spent, X number. So that's also an element that I think
we never had to deal with that.
Right? Yeah, I'm sure you did. I wasn't going to point. I was saying it to make it equal that we also had that experience. But yes, I think we've all been in situations where we are, mid litigation, and we have principals out there that say things that are quite unhelpful to the record that we are pointing to. Is there another question? And Michael, I don't know if I'm running up against time, but I'm good. Great. Okay, go ahead.
I have a kind of a small question that I think leads into a big question, which is during your tenure at General Prelogger, there was a particular case argued about ghost guns, and during the oral argument, I listened to parts of it, and it really sounded, there are these sort of gun kits that you can order and put together a gun, and the question was is that a gun? And it just had really sounded like you yourself had tried putting one together and done the kit. and so I guess first of all, I'm curious if you did do that. But also, I think the broader question is, when you have so many oral arguments, you're before the court so often, how are you preparing for that, knowing that they are in this different range of subject matters, and you have the case law of the different fields and the record, and that you're going to walk in and get grilled, essentially. So I was just curious what the preparation generally looks like for that.
Yeah, well, that's a great question. So, yes, I put together a ghost gun.
Really?
I did. So one of the kind of amazing things about service in the federal government, and when you've got a Supreme Court case and you've got a client agency like their ATF, You've got the whole benefit of the subject matter experts at your disposal to help you get smart on a case and get up to speed and make sure that you're armed with the background information and factual information that you need in order to be a persuasive advocate and be ready to handle whatever the Supreme Court throws at you. And I am a really big believer in the idea that sometimes the best way to really understand a case, especially one like that kind of turns on some real world factual questions of just how much effort does it take to take one of these kits and turn it into a functioning firearm, that you can learn immeasurably from having real world experience. And so I had the opportunity when I was going to argue that case to go to ATF headquarters, and they had one of these ghost gun kits, and I sat down and, turns out all you have to do is drill a couple of holes and file off a few tabs and, plug in the components, and
It's
suddenly
actually quite terrifying.
you have a
but
weapon.
yes,
I know.
how easy it is.
So I
Yeah.
put it together, and then ATF was like, all right, thank you, Madam Solicitor General, we now have to take that because you can't lawfully possess it because it doesn't have a serial number, or, So I didn't get to keep my ghost gun, but I did get the experience.
Did it work?
It did work, but these things are actually quite unreliable, which is one of the problems
Yeah.
with them too. So you don't want to, kind of have this out. But they did take it to the range to test it for me.
Yeah.
So I also had the experience of firing a bump stock actually when we had the bump stock case, which is whether bump stocks qualify as machine guns. And so we went over to ATF headquarters for that as well, and fired bump stocks, and I got to tell you, it felt like a machine gun to me. I got to fire the machine gun too, by way of comparison. So
Don't mess with her.
I know, right? I'm suddenly moving my chair away. Well, but you were probably getting asked also a lot of factual questions by justices that, your direct experience now gave you a little bit more of a lens into.
Oh, exactly. You feel like you just have a much better sense of the real on-the-ground facts that can matter for your advocacy. And, it's not like that's going to be facts that are entered into the record, but I think it's going to give you the confidence to speak from a greater position of authority about your case. And just the kind of tail end of this, on the broader question of how do you prep, particularly as a generalist, it really is recognizing that you are going to have to lean heavily on the incredible subject matter experts who surround you. And for me, that's getting over being worried about asking dumb questions.
Mm-hmm.
I would frequently go to my client agencies or convene groups to kind of just talk through sometimes even what felt like the most simplistic or basic questions in the case. But it turns out the justices are generalists as well. And so I wanted to make sure that I could effectively translate the concepts from this potentially very in the weeds or technical or complex regulatory regime and make it understandable and digestible for the justices.
No? Did you ever do anything akin to this? Not necessarily
Not,
in the, not
I
necessarily
can't, I
in the
certainly
make your
can't
own
compare
gun.
with that. But when I argued the travel ban case, the rationale was a national security rationale. So I wanted to understand what kind of threats we were dealing with. So I don't know if you've ever come into Dulles Airport or really any international terminal where you're kind of walking down the middle and along the lines are these mirrored walls on every side. Well, behind those mirrored walls are a bunch of federal officials. And so I spent half a day behind the walls with them trying to understand what they were looking for and what they were doing. And I spent the second half of the day in the National Threat Center that's near Dulles, where you walk into this massive room and up on screens, they are monitoring who's coming into the United States in real time and collating that with real intelligence so that you can see what they're dealing with. And throughout the course of that day, I actually came up with a couple of examples that I think I might have used at oral argument that were illustrations of why the certain aspects of the order were actually helpful to what the government was trying to accomplish.
So I know we are at time, but I cannot thank you both enough for such a rich conversation. We touched on a lot of topics, but really grateful that both of you could be here. Thank you so much.
Thank you.